Next case on the docket is Kelly versus Kelly.
Good morning. May it please the court. I'm James Dressler. I represent the former husband who was the respondent below in this domestic relations case. These parties were married August the 2nd, 1989. They separated in January of 2005, and the petition for dissolution was filed in February of 2005. Final judgment was entered by the lower court in May of 2007. Now, initially, let me suggest that the wife filed a notice of cross appeal. However, in her reply brief, she never set forth any issues or briefed any issues with respect to that notice of cross appeal. So, under the law, she is deemed to have abandoned any cross appeal. Now, essentially, we have raised 5 issues here. 4 of those issues really relate to the major issue that we've raised here concerning the trial court's imputation of income to the former husband. Now, the court noted in the final judgment, and we believe that this sets forth the court's trial judge's mindset. This is what he said. Respondent's Exhibit 2 reflects that the husband made $553,057 in 2004, but made only $80,862.94 in 2005 and $77,532.27 in 2006. The husband contends that his decrease in income was due to business pitfalls and contract disputes. This court is not persuaded by this position and finds the husband's reason for the decrease in income to be incredible. This court therefore finds either by imputing income or ascertaining concealed income to be a minimum of half of his 2004 income, resulting in an annual income of at least $275,000. Now, unfortunately, our office probably led the court to that error. Now, if the court had considered the testimony, however, he would not have made that statement, because Mr. Poe, who was representing the wife, extensively questioned Mr. Kelly about these losses. For example, on page 29 of the record of the transcript, you say your current salary is $84,000. Yes, sir. When did you start receiving? And he goes on and says he was receiving $81,000 prior to December. Okay. Now in 2003, when the business started going bad, a negative $577,900. Correct. So the record reflected that there was a mistake. And as soon as we caught that and realized that we may have led the judge astray, we filed a motion for rehearing, and attached to that motion a copy of the original financial affidavit that the client had filled in and showed that he did have parentheses around that figure, and it was a negative figure. And also we pointed out that it was a 203 income because he filled it out at the beginning of 205 and he didn't have the 204 income yet. And we pointed out that if you looked at that negative figure and took the tax return of the couple for calendar year 2003, it conformed exactly with the negative figure. But on rehearing, the trial judge in effect ignored that, and he said, well, he didn't address that, but I'm looking at the income of Vimco. Even though it showed a negative, they had assets. Well, if a Vimco had assets, that referred and would have been the subject matter of equitable distribution, not income available to the husband. So under the circumstances, the trial judge, failed to point out the source of this imputed income or the source of any income that he may have concealed. What was the source of this? Under the circumstances, the only income...
One of the things that the judge looked at was history of expenditures or lifestyle, or some evidence to indicate there must be more money there. Is that fair?
Well, this is what he said, but essentially, if you look at the record, he pointed out that the record showed that Mr. Kelly's expenses were $14,000 a month. He didn't indicate in his testimony that he was actually paying $15,000 a month. He indicated that's what the expenses would have been had he been paying them. For example, he had this loan that was due on the house. His testimony was, number one, that the financial affidavit showed $5,500 a month. What he actually was doing is he'd pay that loan for 3 months and pay down the principal, then go borrow the money back and pay it again. The evidence also indicated that he'd used $12,320.74 in the Sun Trust account to pay those bills. He also used $16,879 in a Prudential account to pay those bills. He also used $65,000 in an E-Trade account to pay those bills. The testimony was unrefuted that his mother had loaned him between $30,000 and $40,000 to pay those bills. Testimony also indicated that he hadn't paid the taxes on the house since 2004 because he didn't have the funds. The evidence shows that he was brought back into court because he wasn't making the payments that he was supposed to make, and his testimony was that he was tapped out. He didn't have any other sources. So I have no idea other than the court just pulled this figure out of the air and said, I'm going to say, okay, well, it shows that amount. I'm going to say he earned half of that amount. There's no justification in this record. The testimony...
Well, arguably, he said he earned that amount, or he could have earned that amount, since he threw in both imputed income or hidden assets, right, which would have been two different standards.
Well, that's what the trial judge did. But the reason I read that paragraph is because I think the judge's mindset was, okay, it's unbelievable that he went from $550,000 in 1 year down to $84,000. The testimony was, and the evidence showed, that his income came primarily from RKT. The tax returns of RKT are in evidence. In 2000, they had a profit of $229,591. In 2001, it went up to $331,543. Then in 2002, the business started going south. They lost $1,023,521. In 2004, they lost $988,386. The wife even testified that their standard of living started to decrease in 2001 and 2002. They didn't take any ski trips to Aspen, Colorado after 2001. They didn't go out to these nice restaurants after 2002. So under the circumstances, where did this hidden income come from? They had all my clients' bank statements from every bank account he had. They had the profit and loss statements. They had the tax returns of Abimco, which was a company that was set up down in the Virgin Islands for 3 years to take advantage of a tax benefit. But the tax return shows that that company lost money in 2003. And there's no other place where this income that the judge imputed or indicated that he was hiding may have come from. And there's got to be some evidence in the record other than just pulling a figure out of the air. And that's essentially what the judge did. He never addressed the fact that we had shown that it was our error that may have led him astray because he relied on the document in evidence rather than the testimony. Now,
what's the remedy?
Pardon?
What's the remedy that you're seeking with regard to that?
Well, the remedy is we want this court to reverse and remand for a new trial with respect to what the income of the husband was, and it reflects upon all the other issues.
So it would be a new trial where people could present new evidence?
That's correct, Your Honor. And again, the second
Why
issue...
wouldn't we just remand it for findings?
Remand it for...
Findings.
Well, we could do that. it would affect all the other issues we raised except the last one. We've raised an issue as to alimony. Now, we're not saying that this perhaps is not an alimony case, even though it's on the upper end of the cusp. We're saying that if the court improperly imputed income to the husband, then the alimony would have to be adjusted. And again, the way the court calculated child support, we suggest that the Katsourolis case and the subsequent cases out of the second are the proper way to do it. The judge didn't do that. Essentially what they do there is take the total child support payable by both parties, then divide it equally among the number of children. And in this case, since the husband's obligation was more, he should have retained what was necessary for his child, the one that he had, and paid the difference to the wife. Therefore, they both would have had the same amount. The legislature has never seen fit to provide that because there's a split custody arrangement, the couple should have to pay more child support.
Well, the guidelines are set up, are they not, that the support for 2 children is not twice the support for 1 child, correct?
That's correct.
So presumably the presumption behind those guidelines is there are some economies of scale, if you would, when you're raising 2 kids, correct?
I believe that's what the legislature had in mind.
Those economies wouldn't be there if each of them had 1 kid, primary or full-time, would they?
They would not. However, how do you rectify that? It's a legislative matter to rectify that, not a judicial matter. The judicial matter, if the judge is going to do that, that's legislating from the bench. This problem has been around for a number of years, since the 2nd District first addressed it. The legislature has not seen fit, even in this last session, to address that question.
How did the trial court calculate it in this case?
I have no idea. The trial judge said he filed something. I've never seen what he filed. I think what he used, the method as set forth in the dissenting opinion in the case cited by counsel for the wife. But it was a dissenting opinion.
And what was that method?
I don't...
And what was the method set forth in the dissenting opinion that you think he followed? How was that calculation done?
Well, that's a complicated matter. What they do is they take, okay, number 1, if we're going to say each one of them has 1 child, what's it going to be for 1 child here and what's it going to be for 1 child here? And then they calculate, okay, how are we going to take care of the other children? And that's where it gets a little fuzzy. But I've never seen a method utilized by any court other than what the 2nd District had approved in the Katsourolis case. That's theoretically been accepted by this court and other courts all the way down the line. If there's going to be some modification of that, as I said, it's a legislative matter, not a matter for the courts to determine. Now, with respect to the last issue we've raised on appeal, that would concern the method of disposition of $40-some-odd thousand in personal property. And what the trial judge did is said, okay, we're going to make a list, and the list is here, because you both submitted these lists, and then you're going to alternatively pick. The cases we've cited say that's an improper method of distribution of property because it affords no meaningful appellate review.
Now, one of the things the trial judge also said, which I didn't understand how it worked, it sounded like he said you're going to take turns picking, but it's not going to be on number of items because we want it to be equal in value. And I don't know how you do both. How do you alternatively pick items but equalize value at the same time?
You don't, and that's why the courts, and I've cited the case where the court said that's not an appropriate way to do it because there's no way that you could comply with equitable distribution and have an equal or equitable distribution between the parties. Not only that, he said the husband gets to pick $10,000-some-odd worth of assets before they start this alternate picking. Now, the only time it's ever been approved is where both parties conceded that that would be a method of doing it, and the reason it was approved is because then they waived any appellate review of that because they've agreed to it. So we believe that under the circumstances here, child support, alimony, attorney's fees, as we pointed out, all ought to be decided based upon what the husband's income is. We pointed out in our brief that the court didn't make the necessary findings with respect to setting an attorney fee. Also, that the court did not use the proper method in calculating child support, and what the wife's alimony should be would be dependent upon what the husband's actual income is. So if we reverse and remand for making findings, that essentially would resolve all those issues.
Mr. Dressler, let me just ask you, was there any, did you ever tell the trial judge that you opposed this method of dealing with the tangible
Yes,
personal
we
property?
did.
When did you do that?
During the course of the trial, we told the judge that wasn't an approved method of doing it. He said, well, that's the way we're going to handle it. I suggested that, okay, you may want, and an approved method would be to have one party make two lists and then let the other party choose. That method has been approved. But the judge says, no, I'm going to go ahead and do this alternate picking method.
And you didn't object to that in the motion for rehearing?
We didn't raise it on the motion for rehearing. We thought we had preserved our right at the time of trial.
May it please the Court. My name is Joseph Colmer, and I represent Jackie Kelly in this matter. As the Court is aware, this was a marriage that lasted approximately 18 years. And
Did the trial court impute income to the husband in this case?
Your Honor, the trial court's final judgment is a little confusing on that point, but
Doesn't that make it either difficult or impossible for us to correctly review it on appeal, since if he imputed income, we have to use certain standards to review that. If he found there was hidden income, we have to use a different standard to review that. If he found there was part of each, we'd have to know how much each part was so we could effectively review it.
Judge, we do not necessarily agree on that point, and the reason is this. The fourth DCA, the cases cited within the wife's brief, document the Bromson and the Nadrich case, where in those cases both the trial court and the appellate courts have used the term impute. And that may be improper under the statute, but both the fourth DCA and the trial court in those cases used the term impute when the court made a factual determination of either hidden, concealed, or income that they didn't know where it was coming from. So the trial court, under those circumstances, and those are the cases that we rely on in this case, and we can distinguish clearly any of the cases cited by the appellant in this case, that Bromson and Nadrich, and specifically, Your Honors, Nadrich, cites that in that case, the trial court was faced with an issue of making a determination as to the credibility of witnesses, being in a superior position, but also looking at income, debt, and income ratios that didn't seem to make sense. A CPA testified in the Nadrich case, which also happened in the case before this court today, that testified that the husband's numbers did not make sense, that he had offshore accounts and companies that he could manipulate and use and bring in income, shift income to hide. And the court in Nadrich, the 4th District Court of Appeals, said that the trial court had no choice but to impute income under those circumstances. And even though the 4th DCA used the term impute, Your Honors, they did not have to find specific facts as recommended by Mr. Dressler. In fact, all they had to do is make a factual determination with no specific facts relating to the amount or the source of income, as long as the record evidence confirmed that. And our position in this case, Your Honors, is that the record evidence in this case is full of reasons why the trial court's judgment on alimony and the imputation of income should be affirmed.
So it's not imputation in the classic sense of this person is underemployed, they're purposely not working in order to not have to pay, and we're going to impute how much they could make. It's really, we're not going to believe his income figures, and we're going to come up with a different income figure based on all the evidence.
Yes, sir. That's the position that we are taking. And if you look at not only the final judgment where the court discusses the difficulty he had and the fact that he specifically states that he found the husband's testimony to be not credible. Also in the order on rehearing, the judge again addresses that there were a lot of conflicts in income.
Is there a dispute as to whether or not the husband made or lost $500,000 the year before the divorce?
Judge, our position on that is that, number one, that was not correctly preserved at the trial court level. There was never an issue where the appellant objected or made a note in the trial court record to make the suggestion that that was a mistake, not until after the final judgment. And if you read the final judgment carefully, as well as was
there any testimony that he did make $500,000, or was it just the affidavit that they later said was incorrect?
If you look at the record, and specifically the testimony of Mr. Bouvier, the CPA hired by the wife, Mr. Bouvier was hired to look at all of the financial documents provided by the husband. And we will disagree with the appellant's argument that the husband provided every tax document, every source of income. Because Mr. Bouvier cites in volume 4 of the record where he specifically asked for certain documents on a VIMCO, that offshore account, that offshore company located in the Virgin Islands, as well as a second company by the name, located by the name of Corp Services Group that was owned and operated by the husband. And Mr. Bouvier asked for those specific records, was not provided those records. His testimony confirms that in the 3 years prior to this divorce, the husband earned in profits from a VIMCO and that other Virgin Island company over $1.2, $1.3 million that were distributed, according to Mr. Bouvier, directly to the husband in this case. That was not to be found in any of the financial documents provided. And in fact, the husband had an opportunity to provide documents to contradict that. They were never provided.
So that was the cumulative of the 3 years prior to the divorce?
Yes, sir.
Inclusive of the year that they now say they lost $500,000?
Yes, Your Honor.
What was the testimony as to the 2 previous years? I mean, would the calculation work out that it was a negative because he made $1 million in each of the earlier years?
No, Your Honor, not based on the record and the evidence provided. And Mr. Bouvier addressed that as well within his testimony contained within the record. And Mr. Bouvier testified without a doubt that there were assets missing, that there was income that could not be accounted for. And he sent his staff to spend an entire day, but they were limited by the actions of the husband and his failure to provide certain documents. Your Honor, the second point addressed is the issue of alimony itself. And we believe that the trial court, within his final judgment, addressed the specific factors outlined in 61.08 subsection 2.
Well, doesn't that argument really flow from the first argument? So
It does.
It's really dependent on whether we find the income figure is correct or not?
Yes, sir. And again, we would rely on the cases out of the 4th District. And there are cases, Your Honor, in the 5th, where the 5th has also followed that 4th District opinion that where there is a factual determination due to the lack of credibility, confliction within the record, that the judge can make a factual determination without the requirement of having to make factual findings specifically as to the amount and source of imputation. The second issue that I will address, in skipping over the alimony, is the issue of child support.
Specifically, can you tell me how the trial court calculated the child support in this case?
Judge, I've spent a lot of time, and I will acknowledge to the court that I am not very good at math, but I believe I have determined how he did that by looking at the order on rehearing and his final judgment. In my opinion, what the court has done is he has taken a modified version of the 2nd District Winters and Gongola case and used the Simpson case to come up with a method where the trial court had the present net monthly income of both parties, brought it down, used Chapter 61 to determine the basic monthly obligation.
Wait a minute, let me stop you there.
Yes, sir.
On a basis of the number is X for $2, or that the number is X for kid 1 and X for kid 2, and you've got 2 different kids in 2 different places, so we're going to use the cumulative number, because obviously the support number for 2 kids is not twice the support number for 1 kid.
That is my understanding of what the trial judge did.
So he used which one? The 1 kid number for each parent?
The latter.
I'm sorry?
The latter of the court statements, where he took the cumulative value for 2 children.
Okay.
Yes, sir. And when I did this, and I spent a lot of time trying to figure this out so I could hopefully try to explain to the court what the trial court had done, is that then he took the percentages of each party, which were 78.32 for the husband, 21.68 for the wife. He then calculated their share of basic monthly obligation and then subtracted those 2 numbers, and after that subtracted another $55 for health costs provided by the husband. And that is how I came to the number that the trial court came to. And, Judge, on that issue, our position on that is the 2nd DCA does have a manner that they recommend, that they want to use. I think it's clear how difficult this is when you have split custody based on the writer of the 2nd DCA opinion in Gogola where he acknowledged he had made a mistake in Winters and had to go back and correct it. This is a difficult issue. Unfortunately, it does not appear in all of the research I have done that the Fifth has ever addressed this specifically. The Fourth has, in the Simpson matter. And in a very well-written dissent, the Fourth has come up with sort of something that they argue could be an alternative, at least the dissent has. In this particular...
Let me see if I understand how you've done the calculation.
Yes, sir.
Let me use a simple example. And let's take out the health insurance piece because we don't need that in.
Yes, sir.
If the child support guidelines said for 2 kids the total support was $100, and the court found that the husband made 70% of the income, the wife made 30% of the income, is it your understanding what the trial judge then would have done is said, okay, the husband's obligation is $70, the wife's obligation is $30, and then what would he do? Somehow net those out, or who would pay what to who under that?
It's my understanding, Your Honor, that he subtracted the 2.
And so the husband would pay to the wife the $40 difference?
Yes, sir. That's my understanding of how the court, and as Mr. Dressler stated, I have also not seen the child support guideline worksheet that the trial court used, but when I did these numbers, when I worked them out, using Winters, that's the numbers that I came up with. Yes, sir. And Judge, our main point on the child support issue is that under Simpson in the 4th DCA following Kanakaris, the trial court, because the Chapter 61 does not specifically provide a protocol for this, therefore the rule of discretion applies. And unless this court finds that the trial court's calculation is arbitrary or unfair, then it should not be reversed. And we would suggest that when you look at the confusion within the DCAs, the 2nd DCA's stance, the 4th DCA stance, and the lack of anything from the legislature in Chapter 61, that the trial court was well within his discretion to come up as long as he explained it. And I believe he did, Judge, because I was able to figure it out, and I'm horrible in math. So if the trial court explained it to where I could figure it out, I believe he has followed within his discretion based on the testimony and evidence presented. In regards to the attorney...
How do you get from your client's testimony or your expert's testimony as to how much money the husband made in prior years to a conclusion that therefore we're going to determine that his income is half that number? What evidence was there that would have allowed the trial judge to say we can take this number and cut it in half?
I believe what happened, Your Honor, is taking into consideration that the trial judge is in a superior position to judge credibility, to review the evidence, and to make that determination. What he did was he heard the testimony of the husband. This was a trial that lasted over 3 days. During that time, the husband was cross-examined vigorously by Mr. Poe, the trial court attorney in this case. During that process, he stumbled, continued to contradict himself on what he was paying in those $14,000 worth of debt each month. Sometimes he would say, no, I wasn't paying all that. Other times he would. If you look in the record, Judge, one of the very interesting things that the husband testified to was that he paid taxes as if he were taking these huge losses. But yet he testified that he didn't have the money to pay that. This husband was a CPA. He had the ability to let the government know that, you know what, I'm taking these losses, therefore I'm not going to pay all of these taxes. He never did that. That does not make sense. There are conflicts in his testimony that Mr. Poe brought out. When you take into consideration also the testimony of the wife, we disagree with what the appellant has suggested, that the wife testified their lifestyle went down well before the petition. If you look carefully at her testimony, she acknowledged that her children, once her husband moved out of the house, continued on trips every year with the husband. His lifestyle continued. She could barely pay the bills, but he continued to live the life that he had, and that never changed. And then you take into consideration that the husband was provided every opportunity to give every document regarding that Avimco corporation with all that money that went somewhere. A trained CPA hired by the wife had spent an entire day with his staff and couldn't determine where those monies went, but he did say, based on what he saw, they went to the husband. That was his testimony.
Let me tell you what my concern is. I could see a trial judge saying, here's what the pattern of income was. I'm going to find that pattern was not substantially changed, so it's X dollars. I could see a trial judge saying we can look at what his lifestyle is, what his expenditures are. We can take those numbers, we can calculate an income number, and it's going to be X. I am somewhat concerned that what the trial judge said is we're going to take half of this income number. seems somewhat arbitrary that it's all of a sudden just half of some number as opposed to some way or method to calculate this number is based on the lifestyle, the expenditures, etc. Was there testimony, for example, from the husband about a downturn in the business and problems with the business that the trial court could have used to say, okay, there's a downturn, but I think it would have only accounted for half of his income or something like that?
Judge, my recollection in the record is that there was testimony from the husband to that effect. Yes, sir. And, Judge, I certainly understand the trial court's concern as addressed in the 4th DCA, where the 4th District Courts of Appeals have said the appellate courts want an opportunity to see this and be able to really make an appellate decision and review everything. But if you look at those opinions, they say that is not necessary. We want it, but we understand the time constraints on a trial judge, and they can be difficult. And the trial judge is in that superior position to determine these things. And although we would like to have a lot of facts laid out on the source and amount of imputation, under the 4th DCA opinions of Bromson and Nedrich, you don't have to, as long as the record substantiates the court's opinion, and we believe it does. Quickly, Your Honor, I'll address the issue of attorney's fees. Initially, the parties had agreed after, I believe, the second day of trial that the husband would award the wife $7,500 in initial attorney's fees. After that, after the final judgment, the trial court entered an order for another $7,500 in attorney's fees to the wife. Based on the record evidence in this case, the trial court for the wife at the time of the trial filed a timely motion for attorney's fees on May 23, 2007. He filed an affidavit spelling out his time and costs and hours. And in accordance with the conversation between the two trial attorneys and the trial court, they agreed that any objections that the attorney for the husband had could be made in writing, and then the court would make a determination as to attorney's fees. The court then awarded that extra $7,500 for a total of $15,000 in attorney's fees out of a total owed to her attorney of $32,631. We believe that the trial court, within his final judgment, identified the statutory factors outlined in 61.16, that he identified not only the income as imputed by the trial court, but also the assets distributed, and that his award of attorney's fees was fair and in accordance with the law. The final issue that I will address is the distribution of tangible property.
And explain to me your understanding of how that was to be done to accomplish both a you choose, I choose method, but then the court saying, but it's not going to be even items, it's going to be even in amount. How do you do that?
I think what the court has to look at is the entire final judgment, which the appellant, with all due respect, I believe shortchanges a little bit. The appellant's position is that the trial court simply said, you guys are going to pick and choose. That's not what happened here if you look at this record and if you look at the final judgment. A list was prepared with specific items, specific values. That distinguishes the Shea case cited by the appellant. In addition, the trial court began the distribution by offering value so that the husband at the end of the court's distribution had $24,500 worth of assets distributed to him that were marital. At that point, the wife had $35,000. The husband had a shortage of $10,500. The judge then had this list that both parties had. The judge said, okay, what I want you to do is, considering Chapter 61, how everything is to start from equal, the husband is to choose from this list items that equate to $10,500, which then makes it equal. Then we're on an equal playing field.
And then what happens? What's remaining on the list, does it get divided up by equal number of items or by value?
By value, Your Honor.
How do you do that when you're picking alternatively back and forth?
My reading of the final judgment is that the trial court instructed these parties to keep in mind that this is going to be equal. Don't worry about the items. You guys are just exchanging the value. You pick and choose the value, and I don't like those terms, but I think under the certain circumstances of this judgment, that is what...
How do you pick and choose value? You've got to pick items. How do you pick value?
The items corresponding with the value. I apologize. The items that corresponding values will equate so that there will be equitable distribution, as the trial court states very firmly, in my opinion, that that's what he wants, that the parties are to keep in mind this is to be equitable, this is to be equal, and that's what I want, and that's how I've started this process. Now, the two of you are to take items with corresponding values that will equate to equitable distribution.
And how do you do that if they don't agree on how to do that? I mean, at least on the you pick, I pick, you have a method. You pick and I pick, there can't be any dispute. If there's an added layer of, and when you get all done, you both have to have the same amount in value, That doesn't resolve the issue potentially, right? It just leads to another fight, because if they can't agree on how they're going to divide it so that each gets an equal amount of value, the court's going to be right back in the middle of it again, aren't they?
Well, I think it does, Your Honor, with the effect that the values are listed, and they're there. And it very well, there could be disagreement on who's going to get what. But the court has instructed them on how to do this, what to do.
Who listed the values?
The husband.
The husband did?
Yes, sir.
And so all of that was determined by him?
Yes, sir. And the court addressed that with both parties and had made a determination that he was going to take the husband's list of items.
So the husband established the values for each item, and then they were supposed to pick?
And there was testimony on that point as well, Your Honor. Yes, sir.
Why would the trial court just not finish his work?
Judge, I believe that the trial court, and it's difficult for me to step into his mind, but my understanding of what he did was that he had these assets, he went through and he started this process, as the court has suggested. And then he outlined how he wanted them to continue this, that above all it was going to be equal. And he started that process and defined it, and then told the parties that from here on, this is what you have to do.
Sounds to me like it might not then even be a final appealable order, because there's something left for the judge to do potentially, and that is there is the possibility that the parties won't agree on how the property is divided, and that the trial court's going to have to step back in and do the division.
That's a point well taken, Your Honor. And I believe the trial court did what he could do to instruct the parties and tell them the way that he wanted us divided. But I wouldn't rule out that that could have been a possibility. Thank you for your time.
Thank you.
Please, the court, let me address the counsel's representation to Mr. Bouvier's testimony. Essentially what happened in this case, and the trial judge found that my client only owned 10% of the company, even though his mother agreed to pay him 49% of the profits as a result. And this court's got to accept that. That's what the court found, and there's no contest with respect to that. Now, under the circumstances, Mr. Bouvier said that, well, these are subchapter S corporations. The income flows through to these parties. And he said, I haven't seen any disposition of whether or not that income flowed through and each of them had it or not. In fact, the testimony from the mother and the son was the only income they ever took out other than the salaries that each of them had was a sufficient amount to pay the actual taxes because of the flow-through aspect of a subchapter S corporation. And in fact,
he paid taxes on all that income, though, didn't he?
They paid taxes on it, and the testimony was that's the income that they took out because they needed this income to stay in RKT to build the business. And that's the reason they took that out, because it was taxable to them. But Mr. Bouvier didn't testify. In fact, his testimony was yes, he knew from public records that RKT had lost over $2 million in a recent state road project in 2005, right before the case went to trial. And there's no testimony in this record that would indicate that there was any income from RKT in 2002, 3, or 4. In fact, it was just the opposite. There was no income from a Vimco. In 2003, there was a loss, and the tax returns were there. Mr. Bouvier was at a loss. He said he didn't know where the income went. Well, it went back into the company, according to the mother and the son, because they needed that income to try to build the company. And of course, you can't pull out all the income in a subchapter S corporation. If you do, the company's not going to last very long. But with respect to the argument on the attorney's fees, there's absolutely no finding in the record by the trial judge that Mr. Poe reasonably expended so many hours in handling this case and that X dollars was a reasonable hourly rate. He never made those findings, and those findings are required if the court is to go ahead and award attorney's fees. As we tried to point out in our brief, the wife had non-marital assets, And of over $150,000 that was awarded to her, the husband had none. The wife also was to get $300,000 out of the sale proceeds of the home from the husband's share, so she ends up with assets of over $400 and some odd thousand. The husband had none left. He had dissipated all those, and the court found that I'm not going to redistribute those in equitable distribution because the testimony was that those assets were used to pay marital debts. That's how that income was disposed of.
On the tangible personal property issue, did the trial court accept the husband's values that he put on the property?
No, there were two. The wife submitted the list and the husband submitted the list. The judge didn't say what values we're going to use. He said you should end up with an equal money distribution.
So do we even have a final appealable order here?
I don't think so.
I mean, I could envision that if there was one accepted set of values, I finally figured out how this could work. You would alternatively choose until somebody got to their half of the number, and then everything that was left would go to the other side. But if the trial court didn't specifically find that the husband's values were the values to be used in that distribution, I'm having trouble determining how they can get to the conclusion.
Even so, as the court said in the Shea case that I've cited...
Opposing counsel seemed to indicate that the trial judge used the husband's values. That's not right?
No, I don't think so. There were two different... The opposing counsel wasn't the trial counsel.
Well, the final judgment says this court will use the Respondent's Exhibit 5 as an inventory list and value of the marital property.
Okay. Well, I assume that what he did is use that, but the wife had also submitted one, so I don't know on what basis he could pick the husband's values and do away with the wife's values. But in the Shea case, they specifically...
Well, the trial court can always do that, right? I mean, that happens in all kinds of divorces. Each side lists what they think the value is, and the trial court decides which one to accept, right?
But let me reiterate what the court said in Shea. This is not an approved method because there is no meaningful appellate review when it's done in this manner. And they said in the Burrs case, the only time it would be acceptable is if the parties agreed to it, and there was no agreement to that disposition. And when you're talking about disposing of almost $50,000 worth of personal property, I suggest that's not a proper way to do it and award and achieve equitable distribution.
Thank you, counsel.